In 2009, I hosted a popular podcast on the Blog Talk Radio medium. One of the shows aired was titled An Inside View of the United States Supreme Court. My guest for that evening was Jesse Holland, a reporter who was assigned to cover the Supreme Court for the Associated Press. I felt that episode was timely, considering that then President Barack Obama was soon to nominate his first of what turned out to be two nominees during his presidency to the highest court. Sonia Sotomayor was nominated and confirmed by the U.S. Senate, replacing David Souter, who retired later that year. The composition of the Supreme Court has changed significantly since 2009. At the time of my conversation with Mr. Holland, it was considered a slim majority depending on what cases were heard. Former Justice Anthony Kennedy was often considered the deciding vote, or in some parlance, the swing vote. Now that was 2009. We're now in 2024. The Supreme Court's composition is now a decided conservative majority, as many of the major important issues are decided along the lines of a 6-3 vote. The Supreme Court's integrity has also been in question, as one justice, Clarence Thomas, has been scrutinized for accepting gifts whose value are into the hundreds of thousands from like-minded millionaires and billionaires. Then there's Justice Neil Gorsuch, whose own mother was a government deregulation advocate, and he's made decisions along similar lines. Then there's Brett Kavanaugh, who during his confirmation hearings was the subject of credible sexual assault allegations by a former female acquaintance. Finally, the Chief Justice, John Roberts, has a litigation history of disenfranchising the vote, gender equity, civil rights, and affirmative action. And he was the person who reportedly steered the court in framing an opinion that implies the president is above the law, the president being granted broad immunity when carrying out official acts that, I will add, were never specified or defined by the court. In effect, that decision has paved the path for Donald Trump, who recently was elected to a second term, and enabling him to weaponize the government for his own bidding. The court has also overturned legal precedents that had stood the test of time for decades. Those issues include voting rights, civil rights, abortion, and matters dealing with governmental administrative law. We're going to go right into the conversation that I had with Jesse Holland. And if you like the content that's been provided in this segment, hit that subscribe button, give my content a thumbs up, share my content among others, and I definitely welcome comments in the section below. And good evening, Mr. Jesse J. Holland.
Good evening. How are you?
I'm doing fine. Had a little glitch there in the intro music. Didn't even get to hear any of my Steely Dan.
That's how it goes sometimes. But, as long as they can hear you, everything's all right.
Yeah, right. All of a sudden, the screen just went, and then there went, and then all of a sudden it started playing Pink Floyd from the show from April 15th. So you know how that goes. Well, Mr. Holland, I take it's been quite busy for you lately, and it's going to get only even busier later this summer.
Yeah, you got your cycles. It goes up and it goes down. But right now we're in an up period, and it's going to be real busy around D.C. for the next few months.
Right. Now, everyone, I mentioned on the onset about Mr. Holland. He covers the U.S. Supreme Court for the Associated Press Bureau in Washington, D.C. Being a former newspaper reporter, I will tell you that he is considered to be at the top of his profession by virtue of working for the AP and for one of his most important bureaus. His coverage of the High Court includes nominations of Harriet Miers, which ended in hers being withdrawn by then President George W. Bush, and then the appointments of Chief Justice John G. Roberts, and then later with Associate Justice Samuel Alito. With that said, Jesse, we're going to go right into this.
All right, let's get into it.
Now, one thing about covering the High Court, and I term this show as an inside view of the Supreme Court.
Right.
One of the things that people don't really know about is that some consider that as, let's be quite frank, bold about it, one of the whitest beats in town.
Well, it is. If you're looking at it from a African-American perspective, I think when I came to the Supreme Court beat in January, I am only the second African-American reporter ever to cover the Supreme Court on a regular basis. And I am the first African American reporter from a major news outlet to be stationed in the Supreme Court building on a daily basis. So it's not selling it short to say it was. It used to be one of the whitest beats in Washington D.C. But hopefully, as we go on, we can change this.
Right. Now, you mentioned the second. The first one I understand is Stephen Henderson.
That's right.
He was assigned there through the Night Ritter news services, and I just know from my experience, my reporter years, about what you have to get past it, and you understand that it happens sometimes, though. But it is a different thing to be the only one, or maybe one of the fewest, among the fewest, where your pigment is not entirely the same, or the coarse, your hair is a little coarser. Well, maybe not in your case, but I had to jab you on that one there.
Yeah.
But for me, all right, let's just say for me, all right, forget it. Forget it there. But the fact is, it's a different world when you're the only one.
Well, I laugh because one of the things that I don't do in the Supreme Court building is wear my identification badge. Everyone's supposed to wear an identification badge in the building. But for me, I don't see the point of me wearing it because, I'm one of the few black men walking around there. The security guards, I guarantee you, know who I am.
Right.
So I don't see the point of wearing a security badge because there's not many of us around in the building to begin with. But there are some African Americans who've written stories about the Supreme Court. I'm not going to say that. But on a daily basis, I am usually the only African American face I see in the building. Now, when there are big cases coming up, like the New Haven firefighter case, which is a reverse discrimination case, that
we'll
came
be
up
talking
a
about
couple
that
weeks
later.
ago, there were other African American reporters who showed up for that day's case.
Mm-hmm.
But when the next day came, I was in there by myself again. So
yeah,
I mean, it's a huge, covering the Supreme Court is a huge responsibility, and it's even more so when you are the only member of your race in the press corps.
Right.
Because anything you do,
it's going to be
rightly or wrongly, will reflect on every other African American reporter who comes behind you.
Mm-hmm.
So that's one of the things that you also have to watch, being an African American reporter in a building where there are not that many African American reporters.
Yeah, and basically the only blacks are the security guards, or people to push the brooms, or...
Well, there are African Americans who work in the public information office, and they're all wonderful people. There are African Americans who work in the clerk's office, and there are actually quite a few behind the scenes at the Supreme Court. But they're just not the ones. They're not the ones you see every day. They're not the ones you would see if you came to visit the court. I almost said they're not the ones you see if you watch it on television, but as you know, they don't allow television inside the Supreme Court. So they're not the ones you would see if you came to hear cases being argued.
Right. Okay. So unless you know who that person's byline is when you read the paper or read on the internet.
Well, yeah, that's the funny thing. Very few people probably even know there's a African American reporter at the Supreme Court, because you can't tell someone's race by reading their copy. At least you shouldn't be. At least you shouldn't be able to. At least.
Mm-hmm.
No, that was actually, you and I go back to my time in South Carolina.
Right.
The funniest thing that has ever been said to me as a African American reporter was said to me back then from a television reporter in South Carolina. We were trying to start up a National Association of Black Journalists chapter, and a black male television reporter came up to me and said, "You're Jesse Holland." I was like, "Well, yeah, I am." He said, "Oh my God, you're black." I was like, "Yeah." He said, "Well, you don't write black." And I'm like, "Oh, okay. How does one write black?"
Well, obviously, that we're going off into something else, though, but that's a compliment to you that your skills are such that they don't know. I mean, good writing is supposed to transcend race anyway.
It's supposed to transcend everything. So I guess I should have taken that as a compliment, but I took it as, man, that's a dumb question.
Yeah, well, hey, that's a TV person.
It's a TV person.
Yeah, you know how dumb they are anyway.
Let me just say, some of my best friends are TV people. But,
Well,
but
look, we were brought up on the serious reporters were the print and wire people, and the dumbheads were the electronic people.
that's certainly the way what we thought when I was in college. But it seems like the electronic people are taking over the world now.
Yeah.
As I said, talking on a blog talk radio show.
Well, anyway, we're gonna go into a couple other things now.
Yeah.
One of the main things that is really in the news, one of the main things has been our president with the much anticipated his nominee for the court.
Right.
But first off, have you had a chance to be in a room when our president is talking?
At this point, I actually went over to the Supreme Court in January.
Mm-hmm.
So, as I was starting at the Supreme Court, Barack Obama had not yet been inaugurated. So I have not yet had a chance to spend time with him as president.
Okay.
I was out on the campaign trail with him as he was campaigning. And of course, I knew him as a senator from Illinois when he was in Congress. But I have yet to spend time with him as the President of the United States, simply because I'm spending all my time in the Supreme Court.
Right. Okay. Well, that said, you've had some exposure in the past few months with. Have you had any exposure with any of the justices? And what I mean by that is, now I'm not sure how the protocol is though, but have you had any direct contact with them?
Well, the protocol is sort of weird with the justices. Now, in my time with the Associated Press, I've worked in the White House, and I've worked in Congress. In those two buildings, the problem is not getting people to talk. The problem is getting people to stop talking.
Ah, right.
At the Supreme Court, it's completely different. The justices do not talk to reporters, period.
Wow.
I actually have been to 3 after-hour events that the justices have done. I've gone to one with the oldest justice, who is John Paul Stevens, who is 89 years old.
Mm-hmm.
I've gone to one with Clarence Thomas, the only African-American justice on the court. And tomorrow, actually, I will go to a private event that we think most of the justices will attend. They actually, as an annual tradition at the Supreme Court, they bring in an opera singer who performs inside the Supreme Court building. They call it a music hall. That's actually tomorrow, and most of the justices will be there. And I think actually it's going to be broadcast live on NPR.
Okay.
So this will be the first time I will be in a relaxed setting with all of the justices, or at least as many as decide to show up. But even in those settings, it's unusual for a justice to come and actually talk to a reporter. Now you may get an offhand comment, you may hear what you hear, but just as a rule, it's very rare for a justice to actually sit down and talk to a reporter. I mean, sometimes you'll see them on 60 Minutes, or basically if they have something to sell. If they're selling their new book, they'll do TV interviews, they'll do newspaper interviews, but on a regular basis, it's unusual. I'm not going to say it's impossible, but it's unusual for a justice to actually sit and have a conversation with a reporter, which is, for me, is so strange given the work I did at the White House and at the Congress, where everybody talks to you.
Right.
Here, nobody wants to talk to you, at least.
I'm thinking like among the noted elected officials, I'm thinking like Joe Biden is probably one of the best quotes out there.
Oh, he was one of the best quotes in the Congress, and I assume he probably would still be one of the best quotes in Washington if he didn't have handlers all the time telling him, Vice President, you probably shouldn't say that you're not letting your family get on airplanes or on subways.
Right. So what is then said about some of the justices, at least what you've heard? This is my suspicion now, okay, in terms of best personalities. If, among media folk, we tend to term folk as, jerks, great quotes,
right,
or, stiffs, or what have you.
Well,
given that context, my guess is that Scalia and Breyer are probably the two more affable justices. Would that be somewhat close, or are you hearing different?
Well, I actually, and I forgot to mention, I actually went to an event with Justice Scalia, I think maybe a week and a half ago, when he was talking to law students at American University here in Washington. And you know what? The man was actually funny.
Mm-hmm.
He's sitting here talking about some obscure clause to the U.S. code, and he's cracking up people who don't even know what he's talking about. And I'm basically talking about the reporters in the room. None of us have law degrees, so we're all trying to keep up with what he's talking about. But he's being hilarious.
Mm-hmm.
I mean, he's dissing Ohio State University and their law school. He's cracking jokes about other justices. Now, you would think, looking at Justice Scalia, that this is a stern man. He's conservative. He's strict constructionist. You wouldn't look at him and see funny.
I could see that possibly. I mean, I'm like our president. I'm going to speak for myself now, okay?
Okay.
I am like our president, where I am just philosophically opposed to what he stands for, okay?
Right.
But it would not surprise me.
Well,
because among certain people, he's probably the the life of the party.
Well, I can tell you this: he certainly surprised me, and this was my first occasion to hear him speak outside of the courtroom, reading an opinion. But he certainly surprised me with his humor. I would also venture to guess that Ruth Bader Ginsburg is probably also a pretty pleasant and mildly funny person if you get her outside the Supreme Court building.
No, she would be, in my opinion, that real stay-it type of person.
Well, I don't think so. She actually is the host of tomorrow's music hall.
Oh.
So I'll actually get a chance to hopefully to actually say a few words to her, and hopefully I'll be able to suss it out a little more. But given the limited contact we have with these justices as reporters, you try to take what you can from little statements they make here or little statements you read in between the lines of a Supreme Court opinion, and you see a little flash of something here. But all of this is done with very limited. All of my profiles are being done right now based on very limited information. Oh, wow. Simply because I came in the middle of a Supreme Court session. They started in October. I didn't show up until January.
Right.
So they had already started this year's work. Now, hopefully, after the session ends in June, I'll get a chance to actually sit and talk to some of them because they won't be working.
Right. And that's probably your best chance. It's kind of like the off season being
right. That's exactly what it is. It's the off season. Well, normally it's the off season, but of course this year we have a Supreme Court nomination, so all of us will still be working. But for them, for the 8 justices who will still be on the court, it'll be their off season.
One thing that I've noticed with some of these issues in the court, I just happen to just highlighted this one though, but one of the hot button issues that I'm certain that you may hear at some point is about the one over pro-choice, abortion, what have you. I noticed that now their languages, the pro-choice folk, their language has changed from pro-abortion to right to privacy. Have you noticed that?
Well, that's one of the. If you listen to Justice Scalia talk, that's one of the code words that's used, because what they helped decide Roe versus Wade on was that the Constitution recognized the right to privacy. Well, people who are strict constructionists, these are people who say if it's not in the Constitution, it doesn't exist as far as constitutional protections go, will quickly say, well, the Constitution does not provide you with a right to privacy. Which, if you read the Constitution word for word, the word right to privacy is not in there.
No.
So that's one of those code words that they use. But if you look up and down the pipeline, the Supreme Court only takes a few cases a year. And if you look up and down the pipeline, right now there are not any abortion cases in the pipeline for the Supreme Court. So we know at least for the next year, the Supreme Court won't have anything to say unless it's an emergency case. They won't have anything to say about abortion. What we're doing right now is we're looking at cases that the Supreme Court will start hearing in October. Mm-hmm. And right now, there's none of the cases that they've agreed to hear in October so far will deal with abortion. So that means we know we'll go through at least 2011 with the Supreme Court having nothing to say about abortion.
Wow.
So it's one of those weird things. You would think, given the battles in America over this issue, mm-hmm. that this would be something that the Supreme Court would revisit over and over and over. But they're very strict about what cases they hear and what cases they won't. Like I said, right now, they're deciding the cases that they'll hear from October 2009 through June 2010. Mm-hmm. And right now, there are no abortion cases that we have seen that they will hear next year. Now, of course, they'll keep deciding what cases they're going to hear through June of this year. So something could always come up. But right now, that issue is not on the Supreme Court's docket.
It's interesting. I'm no law person. I got a degree in journalism as well. But one of the things I recall in my research, now that was really the basis by which Justice Warren Burger cast a vote siding with Roe versus Wade. And he supposedly is a constitutionalist or whatever that other term is as well.
There are plenty of people who on one side of the issue who will say that he was wrong. Mm-hmm. And
depending on
like I said, you can. One of the things I have learned covering courts, in addition to covering the Supreme Court, I actually covered the trial courts and the appeals courts in South Carolina before I left the state. But one thing that you can learn, you can actually see this by just watching the news right now, is that lawyers can argue a legal point on anything. If you're watching the news right now, one of the big controversies going on is that one of the federal appeals court judges in California is the guy who wrote the torture memos for the Bush administration.
Okay.
They were able to find a legal argument that said that, quote unquote, enhanced interrogation techniques were legal. So I take that and when I talk to people about the court, I say one of the things that you can say for about the law is that you can find a lawyer to argue a legal rationale for anything.
Yeah.
and one of the funniest things that the Supreme Court does is that every year they have like a mock court competition. And they've taken a habit of taking a Shakespeare play and saying, well, what if this person sued that person? For example, take Romeo and Juliet. What if Romeo and Juliet's families sued each other because of the deaths of their children? Mm-hmm. Who would win that case? How would you argue that case? What if they sued the government because they didn't prevent their children from committing suicide? And the Supreme Court will actually hear this as a case.
Wow.
And I missed the one this year. I think they did Othello this year. I actually have a 2-year-old and a 9-month-old here in my house with me. So a lot of times I try my best to attend these things, but sometimes, with children, you just can't.
Right.
So I didn't get to hear the one this year, but I'm really looking forward to the one next year. Now, the Supreme Court justices don't argue these cases, but they judge the argument of the lawyers. So,
right.
So they do have a bit of a sense of humor in some of the work they do. But like I said, lawyers can argue a legal point on anything, regardless of whether. And that's one of the things I also say about lawyers is that a lawyer's argument is legal until someone says it is not. Mm-hmm. The Bush administration's legal opinions on enhanced interrogation techniques was legal until a judge said they weren't. Now, once the judge says they're not legal anymore, then
what?
of course, yeah, they're legal. Mm-hmm. But until a judge says this is not legal, then it's legal.
Okay.
Isn't that that's one of the weird contradictions of the law, you know?
Right, because the president is like, it almost implies that the president is above the law.
Back in 2009, I hosted a weekly podcast on the Blog Talk Radio platform. Blog Talk Radio at the time was a pioneer in podcasts for social media, much like the current live streams that now include the visual element. One of the things I wanted to accomplish early on with the podcast was that I wanted to take on issues of the day. Thus, there was much discussion at the time about former President Barack Obama's first Supreme Court nominee. We're talking about a different time and, dare I say, a different era. We're talking about 2009. Much has changed, but I submit the content is timely. Jesse Holland and I had a conversation about the Supreme Court based on the major issues of that day, offering a glimpse of how things may transpire in future Supreme Court terms. The Supreme Court in 2024 is very, very, very controversial and contentious, and it's also held in very little esteem.
Well, the president is above the law until someone tells him he's not.
Okay.
That's why we have a court system.
Mm-hmm. The checks and balances.
Checks and balances.
Right.
Until for example, take Congress. If Congress passes a law that someone thinks is unconstitutional, it is not unconstitutional until a court says so. So in between the point of whether Congress passed this law, the president signs it, until we get to the point where a judge says it's unconstitutional, that law is enforced.
Right.
The same way goes for the administration. Until someone sues and asks the judge whether this is unconstitutional, it is constitutional.
Right. And then when the judge says so, that's it.
And then it's concrete until a new Supreme Court comes along. And that's one of the things that's most interesting about it, is tracking the opinion about the law back over the years.
Right, because that becomes the basis of argument, or where they challenge the precedent. Right,
exactly. That's it exactly, because what this current 9-member court says the law is could be completely different from what the new 9-member court does when a new Supreme Court justice comes on the court in October.
Right.
So it's all about what the Supreme Court says at this point. If the Supreme Court heard Roe v. Wade from the beginning, right now, they may not come up with the same result that the Supreme Court did when Roe v. Wade was argued the first time. So it's all about when the case is argued and who's sitting on the court, which, of course, is why the selection of a new Supreme Court justice is so hotly contested in Washington.
I understand that this court will be looking at some closely reviewing cases that involve civil rights law, and one of them involves the case with a fire department in Connecticut. Let's see, New Haven, Connecticut, where apparently the problem is there was a group of firemen who took tests for promotion. It was like 50 of them or so, if I'm not mistaken. Is that about right? No, it was over 100 of them. No, it was over 100 of them that took who took the test. About half of them passed. If I'm reading my notes correctly on this, bear with me. All right, 118 people took the test. 56 passed. Of the top 20 scores, all of them were white. None were black.
White and a couple of Hispanics.
Yeah, who were considered white and Hispanic.
Right.
The argument is that the city of New Haven threw out those test results because they felt that it had a disparate impact among minorities because none of the blacks passed the test. And the argument has been that, well, at least there's been a noted, a well-established argument, presumably, that blacks have often scored less than their counterparts on these standardized tests. That's the crux of the argument, right? And the white firemen feel that they are being wrongly discriminated because they, based on the empirical information, they passed the test, they should get their promotion. Whereas, go ahead.
Well, this is one of the cases where there really are no bad guys.
Mm-hmm.
What the city of New Haven tried to do was come up with a test to choose out of their firefighters who should get a promotion. They study and they come up with this test. And when they give the test, the top scorers on the test are all white and with a couple of Hispanics.
Right.
Well, when the city of New Haven sees the result of this test, well, they say to themselves, well, if no one who is African American scored well on this test, well, there must be something wrong with the test.
Systematically speaking.
So what they wanted to do was throw the test out and come up with a new test.
Mm-hmm.
Well, the people who scored at the top said, wait a minute. You said you were going to give this test, and the people who scored the highest on the test would get promotion. We took the test. We scored the highest. We should get promoted. We shouldn't have to start over from zero and take a second test. Everyone agreed that they would take this test, and whoever scored the highest would get promoted. Now that we've scored the highest, the city is now saying, well, we're going to invalidate the whole test.
Right.
And start over, make everyone start from zero.
And I can see the argument where, hey, look, we studied, they supposed to have studied. Well, what's the problem? But at the same time, I also see the argument, as I mentioned, that where if you're old enough to remember how there was supposedly a cultural bias with the SAT test. And I kind of agree with that.
Because I have to say, I actually never took the SAT.
Well, okay, so you took the ACT.
I took the ACT, but yeah, I know the background.
Yeah, and I kind of agree that there was a cultural bias with those tests. Especially, it doesn't matter if you're black or white. If you're not privy to that type of material and preparing for those tests, you're at a disadvantage.
Correct.
Okay. But the assumption is these guys, being professionals, should have been had access to the same opportunity and so forth. I see both sides of the argument. I see where you're coming from.
This is one of the few cases where it's hard to see a bad guy. Sometimes in discrimination and in civil rights cases, it's pretty easy to see a bad guy. Mm-hmm. It's hard to see a bad guy in this case. Everyone is trying to do what they think is right. Right. The city is trying to make sure it has a diverse leadership in its fire department. The white firefighters are saying, well, we played by the rules. We should get rewarded for playing by the rules. The African-American firefighters are saying, well, something obviously must have been wrong with the test if none of the African-Americans could have scored high enough to get promotion. Mm-hmm. No one's taking a position in this case that can't be defended. So it's going to be interesting to see what the Supreme Court does with this.
And the other thing is that all the courts basically have been rather closely divided on this.
Right. Well, it's one of those cases where, like I said, it's easy to see everyone's side. Mm-hmm. It'll be interesting to see what legal argument the court uses to make its decision and how split the court will be, because the common perception of the court is that you have 4 conservatives,
4 liberals,
the Chief Justice, Justice Scalia, Justice Thomas, and Justice Alito. Then you have 4 liberals, Justice
Breyer,
Stevens,
Ginsburg,
Justice Ginsburg, Justice
Stevens and
Souter, and you have 1 swing vote, which is Justice Kennedy.
Right.
So it'll be interesting to see what alliances are made and what legal arguments are used for them to make a decision on this case.
So how was the New Haven case decided? The case was first tried in federal district court. That court sided with the city of New Haven and agreed they could throw out the test results. That decision was appealed again, and it was decided in the city's favor. One of the justices who heard that case happened to be Sonia Sotomayor. The decision was appealed. It was then taken up by the Supreme Court. Judge Anthony Kennedy, who cast the deciding vote, ruled the city of New Haven did in fact engage in race-based decision-making when it proposed to throw out the test results based on statistical disparity of race. According to Kennedy, the results did not constitute discriminatory intent. There was an argument about disparate treatment versus disparate impact, meaning that no black candidates were refused the opportunity to compete for promotions. But disparate impact was based on no black candidates qualified for promotion. So that was the question: disparate impact versus disparate treatment. Kennedy also came up with these facts. The test was weighted as follows: 60% was written. Each candidate had to score 70% or higher to pass. 40% was oral. For fire captain, the top 9 scores would be considered. 7 were white, 2 were Hispanics who identified as white. Those are the ones who actually met the cutoff. For fire lieutenant, the top 10 scores would be considered. All 10 who qualified were white. Anthony Kennedy ruled the city of New Haven did everything it was legally bound to do in devising a test that would not be construed as racially biased. The company that devised the test also created the study material. The actual test was 100 questions and written below a 10th grade reading level. There was a 3-month study period. Those who helped design the test and candidacy procedures included fire professionals from outside the state of Connecticut and of city populations and fire departments similar to the size of New Haven's. Kennedy also pointed out the test was signed off by the City Firefighters Union. In short, Anthony Kennedy ruled there was not enough evidence to suggest there was discriminatory intent. There was no discrimination based on race. Keeping pace with the court's balance at the time in 2009, the judges who ruled in favor of the firefighters were Antonin Scalia, Clarence Thomas, Samuel Alito, and John Roberts. The dissenting justices were Stephen Breyer, Ruth Bader Ginsburg, David Souter, and John Paul Stevens. And who was the deciding vote? Anthony Kennedy, who also wrote the opinion. Ruth Bader Ginsburg wrote the dissenting opinion. He wrote, "The city of New Haven maintained the right to throw out the test amid concerns of being sued. She pointed out there were multiple flaws in the test itself. She pointed out that other fire departments of similar size devised tests that produced less racially skewed outcomes. She wrote her colleagues who ruled in favor of the firefighters failed to consider New Haven's past history of discrimination, the city's racial composition, as well as the fire department's racial composition. Not to mention, there was little to no representation within the city fire department's supervisory position. At the time, only one of New Haven Fire Department's 21 fire captains were black, and the test results still showed a disparity that black and Hispanic candidates still passed the exam at less than half the rate of white candidates for fire captain. For the lieutenant positions, there were 77 candidates, of which nearly half were black or Hispanic. The highest ranked black candidate was 13th. Only the top 10 were considered. The highest ranked Hispanic candidate was 26. For the captain position, yes, 2 Hispanic candidates were ranked among the top 9. The highest ranked black candidate was 15th. In the end, New Haven reinstated the test results. 14 of the 20 candidates were promoted. The city paid out a $5 million settlement, of which $3 million went to attorney fees and $2 million went to the firefighters. They were also given 3 additional years towards their pension.
Now, Justice Kennedy is assumed to be more a moderate conservative. So on numbers, if it's just a conservative argument, the court watchers normally assume that he will fall to the conservative side, but this is one of those cases where you just don't know.
Right. And in some decisions lately, like with the SEC, Clarence Thomas and Scalia ruled with the majority.
Right.
Which was with the 3, Breyer, Ginsburg, and Stevens.
Well, this is why I call it a perception that there are four conservatives and four liberals in one swing vote. Each judge has his or her own personal experiences that they bring into their decision. So they don't always fall into the expected patterns. But we just group them that way because it's easier to explain to people how they work on the big decisions. Like on a Roe v. Wade decision, we'd expect to see a 5-4 decision one way or the other.
Or affirmative action.
Or affirmative action, we'd expect to see a 5-4 decision one way or the other. You'd have the conservatives on one side, the liberals on the other side, and Anthony Kennedy basically making the decision, having the vote that makes the Supreme Court decision go one way or the other, 5-4.
Ben, in the history of the Supreme Court, only 110 justices.
Right.
17 of them have been named Chief Justice.
Right.
The last justice to be nominated and appointed was Samuel Alito. The justice who is leaving is David Souter, and he'll be the first for our president, Barack Obama. The Supreme Court has had only 2 women to serve, Sandra Day O'Connor and currently Ruth Bader Ginsburg. There have been 2 blacks, Thurgood Marshall, and that other guy from Georgia.
The current Clarence Thomas.
Yeah, that guy from Georgia. Anyway, on most social issues, at least the court has a tenuous, at best, 5-4 majority based on past voting record.
Right.
Conceivably, our president may wind up replacing as many as 4 justices in this term of office. Conceivably, that's what some people are saying. Although it is possible, should he be elected to a second term, he may likely do that. And some people think that it could be a decided 7-2 majority, which would shape this court for at least our kids' generation.
Right, for at least 2 decades or more.
Right.
We're in 2024. The United States Supreme Court is a very, 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 very controversial body of people. The Supreme Court is comprised right now, based on political observations, a super conservative majority in which 6 justices tend to favor very conservative issues. Among those issues was the Supreme Court justices striking down abortion in the Dodds case. Also, affirmative action was gutted. Voting rights have been gutted. And then in 2024, presidential immunity. Presidents are granted broad immunity powers, which in the political discourse of today may seem to favor one particular person, Donald Trump.
Now, most of the justices, at least, let's see, John Paul Stevens, Anthony Kennedy, and Scalia were all unanimous confirmations by the U.S. Senate. David Souter received 90 votes. Ruth Bader Ginsburg received 97 votes. Stephen Breyer received 87 votes. And then you have your more divisive one, more controversial ones, or divisive votes. Alito received only 58 votes, which is among the least numbers ever. And, of course, Clarence Thomas barely got in with 52. With Obama's pick, everybody knows that he must be confirmed by the Senate by a majority. He's got probably 59 votes. At least he's got whoever he chooses probably will be confirmed. Correct?
That is a very good assumption.
What number do you think would be a victory given today's political climate? Would a number in the 70s be considered a victory for Obama?
Well, a victory for Obama would be 51-49.
Okay, but we know he
let's talk reality for one quick second.
Mm-hmm.
The reality is any vote that gets his justice on the court is a victory.
Okay.
Now, it's not a public relations victory, but he still gets someone that he wants on the Supreme Court. Now, it would be a public relations disaster if you could not get every Democrat in the Senate, which either is going to be every Democratic-leaning voter, which is either going to be 59 or 60 votes.
If Al Franken finally gets in, right?
If Al Franken's in, or whoever wins the Minnesota seat,
right?
So at the very least, there'll be 59 votes. there are 57 Democrats, 2 Democratic voting independents.
Mm-hmm.
So it would be a public relations disaster if he could not get every Democrat in the Senate to vote for his nominee. It would also be considered a public relations disaster if you can't get the moderate Republicans to vote for your nominee. So I think right now there may be 2 to 3 moderate Republicans. I'm going to count the 2 Maine Senators, Olympia Snowe and Susan Collins, as moderate Republicans. Now, looking back over the past and looking at the vote counts for the previous justices, you can't really compare them to the current and the most recent Supreme Court justice because the political climate was different. If you brought up, if Justice Scalia was voted on now, I would almost guarantee, let's just assume that John McCain had won the election and he brought up Justice Scalia as his possible Supreme Court nominee, and no one knew anything about it. It is hard to believe that in our current political climate, every Democrat and every Republican would vote for anybody's choice.
Supreme Court nominations and confirmation hearings have become more contentious and have greater ramifications. Sonia Sotomayor was confirmed by a vote of 68-31 by the U.S. Senate. Elena Kagan was nominated in 2010. She was confirmed 63-37. In 2016, Justice Antonin Scalia died in February of that year. Barack Obama nominated Merrick Garland to the seat, but Senate Majority Leader Mitch McConnell refused to hold confirmation hearings, claiming it was too close to the election and the electorate should have a say in the process. That meant waiting until after the presidential election. Donald Trump won that election. Later in 2017, he nominated Neil Gorsuch, a federal circuit court justice. He was confirmed by a vote of 54-45. In 2018, Anthony Kennedy announced his retirement. Brett Kavanaugh was nominated. He was confirmed by a vote of 50-48. In September 2020, Ruth Bader Ginsburg died just weeks before the general election. Mitch McConnell, who famously said he would not hold confirmation hearings on Merrick Garland, pushed for confirmation hearings on Amy Coney Barrett. She was confirmed by a vote of 52-48. The ramifications from 2016 to 2020 were this. Mitch McConnell's refusal of holding hearings on Merrick Garland resulted in the Supreme Court's balance tipping decidedly 5-4 upon Neil Gorsuch's nomination and confirmation. That 5-4 majority was strengthened upon Brett Kavanaugh's nomination and confirmation, and the court tilted to a 6-3 conservative supermajority when Amy Coney Barrett was nominated and confirmed. And truth be said, it will be further cemented now with a second Donald Trump term. It is believed that Clarence Thomas and Samuel Alito may retire, affording younger justices of similar ideology to be nominated and confirmed. The potential of a 6-3 conservative supermajority under the current 9-seat configuration may remain that way for at least 15 to 20 years. It may also go farther right if any other justices, Sonia Sotomayor, Elena Kagan, or Ketanji Brown Jackson, were to be replaced. Now, I mentioned Ketanji Brown Jackson. Outgoing President Joe Biden had one Supreme Court nomination during his presidency. In 2022, Stephen Breyer announced his retirement. Ketanji Brown Jackson, a federal circuit court judge, was nominated and confirmed by a vote of 53-47.
For a Supreme Court nominee. So I would be very surprised. I'm not going to say anything's impossible because when I start guessing, I get in trouble. Mm-hmm. But I would say I would be very surprised if you will ever have a unanimous vote on a Supreme Court justice again. Okay. Because the political climate will not allow it.
All right, so then we're saying then that Anthony Kennedy conceivably was the last person to be a unanimous choice. And he was confirmed in February 1988.
Right.
Okay.
I sincerely doubt if Justice Kennedy was brought up again today that you would get every Democrat and every Republican to vote for them. Now, it is possible, but it's just hard to see that happening because the choosing of a Supreme Court justice has become a political issue.
Oh, yeah.
And opposing the other side has become a Washington art. So it's hard to see anybody getting unanimous support from a Senate. Now, it could happen. There could be somebody out there that President Obama could pick that will make every Democrat and every Republican and every independent in the Senate happy. If there is, I haven't found them. If anybody knows who they are, let me know.
You'll be writing about it tomorrow.
Yeah.
That said,
okay,
you hear a lot of stuff. Okay,
I try.
That's what you're paid. You're paid to hear a lot of stuff.
That's what I'm paid to do.
And based on what's public, our president is not going to be making an announcement for a nominee this week. That supposedly is absolutely out of the question.
They have said that it won't be this week.
But there's a lot of talk that it could be a woman or Hispanic. Right. Or the idea is to the woman who isn't a Hispanic. And there are a couple of names that have come up. For example, I'm just going based on a name.
Right.
Appeals Court Judge Sonia Sotomayor.
Right.
She probably fits that entire confluence right there. Right. But then there are some other names, other women who have been that are being mentioned, like Leah Sears, Diane Wood,
of the Georgia Supreme Court.
Right. Sandra Lynch, Diane Wood.
Right.
Kim Wardlaw.
Right.
And,
who's also Hispanic, even though her name's Kim Wardlaw.
Okay. There we go. Or Elena Kagan,
the Solicitor General.
Right. These are names that have come up. And then there's some other non-judge-like names that have come up. That said, for my listening audience, what are some? What's really going on out there? What really is going on out there? Is it such that now y'all pretty much are fed? Y'all only reported what you're fed, or are y'all really digging up other stuff?
Well, see, here's the thing. The choosing of a Supreme Court justice is a very personal decision for the president. Mm-hmm. What the names that you're seeing in the media are names that we in the media think fit his criteria. Mm-hmm. And are names that we think that we have vetted through our sources, and these are sources who think they know what's going on.
And oftentimes, we are right.
And
there are some surprises. We
are right. But I was actually talking about this very issue with some of my sources today. Mm-hmm. And they pointed out very correctly that John Roberts was on all of our lists for possible Supreme Court justices, but he was nowhere near the top mm-hmm. of what we thought President Bush was looking for. Mm-hmm. And nobody called Harriet Miers as a possible Supreme Court justice.
Well, but that proved outright.
but President Bush picked her because he was comfortable with her. So I say all this to say that the only person who truly knows who's on the president's short list is the president.
And Michelle Obama.
And Michelle Obama. We assume, now once again, say this again, we assume that he discusses these things with her. So, unless you're hearing it from the president, everybody else is guessing.
Okay.
And I was doing some research today, on this issue today. Mm-hmm. The former Chief Justice, Bill Rehnquist,
right.
He didn't know he was on the list until an hour before he was chosen as a Supreme Court justice.
Well,
so the list changes.
Board, right? Yeah,
the list changes. Just because some names are on the list last week doesn't mean that they're on the list this week, doesn't mean that a new name won't be added next week. Because they also have to do the vetting of the justices. President Obama could say right now, I think this person is the person to put on the Supreme Court. Well, what if this person had a nanny back in 1977 and didn't pay her taxes?
Oh, it's over
Boom,
with.
you're eliminated. So now the president has to start back over.
Yeah, and the other issue has been about their people's stocks and ownership of stocks in companies that are
right.
Receiving bailout money and all that stuff, right?
Unless you're hearing it directly from the president or the few people inside the White House that he's talking to,
mm-hmm.
and it also depends on when you hear it from the president. He could pick somebody who he can't nominate for whatever reason. So until the president himself gets ready to say, this person is who I want, they pass all the vetting, they have all the qualifications, and I think every Democrat in the Senate will vote for them.
Man, that's a lot.
That's a lot of calculations to have to make.
Right.
So this is why I discount everyone's list. I mean, I have a list of my own that I came up with the night that David Souter was announced his retirement. I mean, the night that we found out about David Souter's retirement. Mm-hmm. But I will be the first one to tell you, until the president makes his pick, everything is guesswork, including inside the White House.
Okay. We've got about 7 minutes left. I want to give you the opportunity to talk about your book.
I
told you it's going to be a fast hour, man.
Got to get that book in there. Well, for those of you who haven't already bought the book, which I hope there are thousands and thousands of those of you out there who have, let me recommend to you Black Men Built the Capitol, Discovering African American History in and Around Washington, D.C. It'll give you a different perspective of the nation's capital. It takes the nation's capital and it looks at it from an African American perspective. It talks about what African Americans achieved and did inside the nation's greatest monuments. And by saying that, I mean the Capitol, the White House, the National Mall, and other places around Washington, D.C., Virginia, and Maryland. If you come to Washington, D.C., you'll find out a lot about American history.
Now, one of the things that when you were featured with NPR,
right?
I remember this. It was a 5-minute segment. If you all go to npr.org, if I'm not mistaken,
right?
npr.org and go back in the archive, you'll see Mr. Jesse Holland in there. You mentioned where almost at the very spot where our president took the oath,
right,
was like a tent city for the slaves.
Right. Well, when they brought African American slaves to work on the Capitol, now the federal government never owned slaves, but they did rent them. And when they rented these slaves from the local slave owners, the only thing the slave owners had to provide was the slave and a blanket. The federal government had to provide everything else: food, medicine, shelter. So what they did for shelter was they made these people who worked on the Capitol live on the grounds of the Capitol. Mm-hmm. And they put up a basic tent city where African Americans had to live after they finished working on the Capitol on a daily basis. So just about where Barack Obama took the oath of office, right where all those seats were scattered out among the in the grass where Oprah Winfrey and Tom Joyner and all the famous people got to sit.
Right, that's where we slept.
They were sitting on top of where African American slaves, and I also have to say white workers and African American freedmen, this is where they all lived together while they were working on the Capitol, on that very same ground where those seats were sitting.
Ain't that something? And the other irony is that the black folk who literally built the place where our president resides now through January 20th,
2012.
2013.
Right. At least through January 2013.
Right.
At the very least.
Ain't that something?
Now, yeah, the fact that the White House was built by black slaves and is now run by the African-American president is one of the great ironies of this country. And Barack Obama has actually acknowledged some of this back during his campaign and after winning the White House. It's amazing to go back and look at some of the pictures from the early days of the White House. Now, we don't have many pictures of the actual slaves that worked there, but actually that's something I'm working on right now. trying to see if I can track down some of the pictures and names and stories of those original slaves who worked in the White House. I think that would be a great thing for people to know about.
Definitely. Well, Mr. Holland, we've got about 3 minutes left. I certainly do appreciate you volunteering some of your time to talk with me and my listening audience on Maverick Media. Hopefully later in the year I can get you back on. We can talk about just, the interesting twists and turns of covering, that Supreme Court justice, whomever that person may be, because our president said it could be him or her.
It could be him or her. We're all of us are sort of expecting a her, but it could be a him or her, and it's always going to be interesting to see what Barack Obama comes down with in the end.